Okay. Eyaliko omulamuzi wa kooti ensukkulumu ayabize ebyama. Tambuza video. Now kirabika Kyagulanyi ayina ensinza gy'asinzaamu Mukama ey'enjawulo bannayuganda abamu ngaffe gye twetaaga okunoonyereza kutumanye oba oli awo naffe tusabe nga Kyagulanyi. Kubanga ebintu birina engeri gye bitambulamu nga mu butuufu olabira ddala biriko omukono oba oli awo ogwa Katonda. Kano kagenda kuba kawanvumu era nkusaba onnyambe okatambuze. Now ngenda kuzaayoko emabega katono omwaka 2021 nga wayise ennaku 10 nga tumaze olonda because omwaka ogwo twalonda nga 14 bassebo ne bannyabo. Kyagulanyi Ssentamu Robert Bobi Wine yalagira bannamateeka be okutwala omusango mu kooti electoral petition ng'agamba Museveni yabba obululu. Now wayitawo ennaku mbale nga bali mu kwajjana musango, Kyagulanyi alagira baloya be omusango bagugjeyo n'aguteeka mu kooti y'abantu. Omu ku bajjaaji abaali ku pano eyali ewulira omusango ogwo, omukyalo oyo gwolaba ku screen amannya ge nga bamuyita Justice Esther Kitimbo Kisaakye, bassebo ne mannyabo, yavaayo n'ayogera ebitiisa ebyali mu musango gwa Kyagulanyi. However much she was very brief. Wayitawo ebbanga ttono nnyo omukyalo oyo n'awummula ng'abuzayo emyaka 7 okuwummula. Ye yasalawo n'agamba mpummulidde wano eno. Bajjajja baba bakoma ku myaka 6 bwe yaweza emyaka yawummula ng'alina emyaka 57. N'agamba awannyowawo nkitadde ngumaze. Wamala owummula ng'awaddeyo resignation letter ye wa Museveni, wayitawo ennaku ntono nnyo omukyalo ono n'ava mu ggwanga Uganda n'agenda mu exile. Kati wano wali okulya n'okkomba essowaani, ensonga lwaki nkugambye kano kagenda kuba kawanvumu, njagala okatambuze. Juzi waneno nga twakamala olwo ennaku z'omwezi nga 15 yavaayo n'akola posts ez'enjawulo ku mukutu gwe gwa X nga yeemulugunya ku ngeri Byabakama gye yakwatamu akalulu kaneeno era nga naye akkiriziganya ne bannayuganda nti akalulu kano kaalimu vulugu tekaali ka mazima na bwenkanya. Lwaki totambuza vidiyo eno n'otasubwa? Now ng'asinziira mu exile gy'awangalira, Justice Esther Kisaakye avuddeyo n'ategeeza abantu n'ategeeza ensi emivuyo egyali mu musango gwa 2021 Kyagulanyi Ssentamu Robert gwe yaloopa. Wano kinyongedde nze nganze omuntu alabe wale nnyo okakasa ensonga ti Kyagulanyi yali mutuufu nnyo okugjayo omusango ogwo n'aguteeka mu kooti y'abantu. Bino byogerwa omukyala eyali ku pano oba yali ku lisiti y'abajjaaji abaali musango ogwo, omukyala oyo Judge Justice Esther Kitimbo Kisaakye. Wabuuziddwa ebibuuzo, abuuziddwa ebibuuzo bingi era gwe ssebo bannyaba atulaba, njagala opaying attention owulirize omukyalo ono ng'addamu ebibuuzo byonna ebimubuuziddwa, era w'omalira vidiyo eno ogenda kuba ng'otegedde eggwanga Uganda we liyimiridde, because Uganda as a country, any government has 3 bodies that govern the country. Eyina executive ekulemberwa president, eyina judiciary ekulemberwa chief justice, ono omukyala mwe yali agwa. Era y'omu ku baali batunuuliddwa nti singa owunyidde awummula bw'ati, ono omukyala yayinza okuba next chief justice, wabula yakabatema n'awummula ng'abuzeeyo emyaka 7 owummula. Ekyamuwummuza nakyo akyogedde. Abaali baagala omutuusaako obulumbaganyo omujja mu bulamu bw'ensi eno nabo aboogedde. Wabadde ku mukutu ogwa space etegekeddwa Uganda Law Society. Uganda Law Society nno nayo ebyayo si birungi. Naye njagala gwe ssebo bannyaba ndaba owulirize omukyalo n'ebigambo byayogedde. Wallahi njagala owulirize omukyalo ono ogenda kakasa nti Kyagulanyi Ssentamu Robert Bobi Wine alabika ayina ensonda mwatunula ng'asaba nga neekusifu tetugimanyi, alabika okuba nga atuuka mangu Katonda oba nga si ki, waaba asindisa essaala ze noza malayika ezaawula essaala oba yagiwanguzi simanyi, naye ebintu bya Kyagulanyi bitambula bulungi, bitambula bukwakku. Nga EU yakavaayo okusamoninga gavumenti ya Museveni omukyalo ono atandise ate okujjayo okunokola ebyama oba oliawo ebiyinza oyamba bannayuganda bannankyukakyuka okwongera otegeeza ensi this is the government we are dealing with. Ate omukyalo n'alabika yasazeho n'agamba yes wanuwe ngenda byogera, atandise obyogera. Kati njagala owulirize vidiyo eno tukomewo tovaawo.
Okay. Good evening to all those who are listening and who have joined us on this X Spaces. Can you hear me properly? Hello?
Yes, loud.
Okay. So good evening to you all, those who are joining us on X and on any other forums, maybe Zoom and other forums that have been connected to this evening's session. Before I answer your question, Sandra, I want to make a few opening remarks. First of all, in my introduction, I don't know which CV you accessed, but there are a few corrections that need to be made. I was appointed directly to the Supreme Court of Uganda. I didn't serve at the High Court and the Court of Appeal. And secondly, much as when I was appointed, the media chose to read my CV selectively and only highlighted that I'd been teaching at Makerere University, which is the case. But I have a very rich career in civil society, human rights advocacy, and also in legal practice. They may not have been as pronounced as maybe for other colleagues, and I think with this development, I may have to. I will post my CV on LinkedIn and probably on my X Spaces. I'll find a way of posting it so that it can be publicly available. I'm working on my website, and I think I also post it there. So I had the great honor and privilege to serve on our highest court, the Supreme Court of Uganda, from October 2009 up to July 18th to 2023. That's the day I submitted my letter of early retirement to the President of Uganda, President Yoweri Museveni. In submitting my letter for early retirement, I relied on the provisions of the Constitution of Uganda, which make it clear that a judge, irrespective of which level of court you are serving, but I think this applies to appellate judges of the Supreme Court, and judges of the Constitutional Court of Uganda, who can serve up to 70 years, and judges of the High Court, who can serve up to 65 years of age. Once you attain 60 years of age, the Constitution gives you a right to retire. The exercise of this right is not dependent on anyone's permission. That provision still exists in our Constitution, and that's the provision under which I acted. Unfortunately, as is the case with many other areas of governance in our country, our Constitution, the Constitution of 1995, one of our biggest problems that we have, and which has also directly affected me, is that we have, some members, those in leadership, especially, have chosen to read the Constitution selectively. They read and apply and take benefit of those provisions that benefit them, that give them the powers, that give them the authority to hold or to occupy the offices that they occupy, but choose not to read the provisions that give rights to Ugandans or that limit the powers of the offices that they hold. So, in terms of who am I today, I'm a retired Justice of the Supreme Court of Uganda. We shall, I hope, at some point in our interaction, we shall come back to these issues, but I just wanted to clarify that. And I am speaking as a retired Justice of the Supreme Court of Uganda. And my comments are being made in my personal capacity. I'm not speaking on behalf of the judiciary of Uganda. Secondly, I also wanted to, in opening remarks, to say a few thanks, to thank the Radical New Bar and members of the Uganda Law Society. I say this from the bottom of my heart. You've done us proud. As a lawyer, I know there are many challenges that are currently facing, you're currently facing as the Uganda Law Society in individual capacity and as an institution, as a body established by the laws of Uganda, but you've shown resilience. And I'm sure many other Ugandans are looking up to you for guidance. And I want to say, although I was a judge, my primary constituency is being a lawyer. So I've never retired from being a member of the Uganda Law Society, and I make those remarks in that capacity as well. I would like to thank, I'll come back to the Radical New Bar in a moment, but I also like to thank the people who have taken time off. I know it's the evening in Uganda to attend this space. Because it's, in my view, it's an important reflection on constitutionalism and the rule of law in our country. This, we are holding this space at a critical time in our nation when we do not have, we are not speaking with the same voice as Ugandans. We have Ugandans who are very happy with the status quo. And in light, I think the slogan that was recently used in the last elections, that we've made gains and we should protect those gains. That's one category of Ugandans. We have another category of Ugandans who are saying, yes, we made some gains, but these gains are not being evenly distributed in our country. We've made gains in certain directions, in certain areas, but we are not enjoying our fundamental rights. And we are not paying due fidelity to the Constitution of Uganda. And as you know, for that category of Ugandans, many of them have been labeled different names. The most recent titles are like, you're a terrorist, you're a non-peace loving Ugandan, you want to take us back to, I don't know, those days where there was anarchy, or you want to take us to Libya and Somalia and all these other countries in Africa where they are having many different challenges. Now, if it was a question of the debate only, that would be okay. But unfortunately, those in leadership have taken it a step further to use the legal machinery and the military to suppress voices, like the president has used, voices of dissent, or voices, other voices, those who don't agree with them, by locking them up. And as we hold this space, we should not, apart from, you have me, a former justice of the Supreme Court, living in exile. The president of the Uganda Law Society is living in exile. Today is his anniversary. For me, I'm making close to 3 years. You have the leader of a national political party, who cannot live in his home because the military has taken over his home. And I'm sorry to use these words, but that's a post by the Chief of Defense Forces. He's being, they're hunting for him, and if they get him, either he will be killed or, somebody wants, to cut off his private parts. I don't know, either as a trophy or something like that. And that's very unfortunate. Now, we have another category of Ugandans, the ones who are in the middle, who are sort of like saying, okay, for us, yeah, we are watching how things are going, but other people are going to fight for us. Maybe a few in the country or a few outside the country, or leaders of the Western countries. And so we are holding this space at a very important time in our country, where we have just recently concluded our elections. And for some, it is over. But the question is it over? So, so I want to thank everyone who has come, and I want to thank the president of the Uganda Law Society, the Radical New Bar, for your leadership, because you've led, you've continued to lead, and your team, your vice president, I've seen you at the at the forefront, fighting for rights of Ugandans, articulating these issues that are affecting our country. And I want to thank you and to say, well, there are challenges, but all of us, we should not give up on these causes that we are fighting for. So, having said that, now I'm going to turn to the question that you posed, which was what made me choose to become a judge, right?
Yes, please. What inspired
Okay.
your career on the bench, and what moments stood out for you?
Like I said, my joining the bench was, as far as I'm concerned, was not something I set out to achieve as a person. When I became a lawyer in 2020, when I was 21 years old, I was just attracted to the legal profession. Because for me, the legal profession was a profession where you fight for the rights of those who need, protection from oppression. Whether it's a woman who is facing domestic violence in her home, whether it's someone who has been imprisoned for a crime he or she did not commit, whether it's someone whose land is being grabbed and the law is being used to deprive them of their right to own their land. And in any other of those situations, as we know, whether it's a mother or father who's being deprived of their rights to have custody, I was attracted to the law to protect and to use the law to advocate for people's rights. So through my career, which I've talked about, which spanned in academia, legal practice, civil society practice, and even a stint in government, a brief stint in government. I just used the law to serve the people of Uganda, especially in whatever capacity that I was serving. So when the opportunity came for me to be appointed to the Supreme Court, that opportunity was came through two senior citizens of Uganda who approached me and say, "Well, we want to propose your name. Would you like to serve at the Supreme Court of Uganda?" And I remember my response to each one of them, I'll not disclose their names, was, "It would be a great honor to serve." And when that happened, of course, for any appointment to take place, you have to go through the formalities. At that time, the Judicial Service Commission, and I think it is still the practice today, you express interest in a position. The Judicial Service Commission would receive expressions of interest. There was a time when the appointment process was different. It was different institutions like the Uganda Law Society nominating people who were suitable. But I think at that time we realized, and I think I was serving on the commission, realized that that system left out Ugandans who would wish to serve, but maybe they were not nominated by different organizations. So the doors were opened up. And through that system, any Ugandan could express an interest to serve on Uganda, on the judiciary, just like a member can express an interest to be, elected as a member of parliament or to join any other field in our country, to work in any other area in our country. But irrespective of how the names came to the Judicial Service Commission, there would be a short list, and through that short list, there would be an interview, and after that interview, the names would be submitted to the President of Uganda. As you know, that's the procedure under our law. And the President would then appoint appoint the names, the people, but of course, subject to parliamentary approval. So he would nominate the names of persons to be appointed, and then Parliament would vet the nominees, and after the vetting, then the President makes the appointment. So in 2009, we all know that President Museveni was in power, and I was appointed by the President Museveni. I've seen many commentaries about the appointment process. I know, and we can talk about it later, the appointment process has since, gone through some changes, and there are many concerns there, and this we need to talk about that maybe in another area. But in short, I became a judge because an opportunity was presented, and I had been working before in spaces where I saw the power that a judge holds. Because a judge decides disputes. If you have a fair judge, then disputes will be resolved in accordance with the law, and hopefully you can have peace in society. If a judge is not resolving disputes in accordance with the law, then the disputes may go through a legal process, but you will not have, those issues will not be resolved. And of course, that also leads to different other consequences. In terms of what is my proudest moment, I think for me, this question raises two areas. First of all, throughout my judicial career, I endeavored to do justice to all manner of people in the matters that were brought before me. I think the president in his introduction mentioned one of the cases two cases where, which, like the employment case to help you, President, it was Omnyoko versus the Attorney General of Uganda, which was not actually, it was a dissent, but it was an interesting dissent because we all agreed and found in favor of Omnyoko, who had appealed to the Supreme Court. But we took different directions. And I think these, in the interest of time, members or those who are interested can access these judgments from the website of the Judiciary of Uganda. But we took different directions, and I think it will be interesting reading. But my recommendation, I think, President, is that it would be interesting, maybe as we go on, for you to hold spaces where we can look at actually the jurisprudence of the Supreme Court. That would give us an opportunity to look into what has the Supreme Court, what did we decide, what is the current law, and of course, is it good law, or is it, isn't it good law? And that would be very helpful for members of the Uganda Law Society as we seek to build our jurisprudence in the country. And of course, in that interaction, we could also have comparative experiences, how have other jurisdictions handled similar situations. And in my view, that would encourage a healthy debate about whether our judiciary and our judges are getting it right, or if they're not getting it right, what should we do? How could they, how could they approach these issues differently? And of course, for the lawyers too, you'd learn some of the arguments that succeeded in other jurisdictions and which could help, in our particular jurisdiction. I think I'll stop there for now. So one was, let me just add this. So the one was, first one was, my proud moments was whenever we handled an appeal and I did justice to that appeal. What do I mean by doing justice to an appeal? That meant looking at the matter beforehand, the case presented by the appellant, the case presented by the respondent. The appellant is the person who is appealing to the Supreme Court. And then the respondent would be, for those who are non-lawyers, the person against whom the appeal has been brought against. And looking at the dispute, the way that matter was decided by the Court of Appeal, and previously, of course, by the High Court, and the case they initially brought to court, and weighing all that to find where there are any errors of law in the application of the law in deciding the case the way it was decided. And in so doing, I took into account what does our Constitution provide. So for me, the Constitution was always the guiding factor, and any laws, subordinate laws that governed the situation we were handling. And the third governing factor was always my judicial oath. Those who are not familiar with the judicial oath, it provides, when you are assuming judicial office, it provides that you will do justice to all manner of people without favor or ill will, and irrespective of their standing. And the other oath, which we also take, is the oath of allegiance to the Constitution. Those are two important oaths that we take and which guided my work. Now, lastly, I just want to say that the proud moment, but this one is a mixed bag situation, is when I made the decision on March 18th, 2021, to read my reasoned ruling in the Kyagulanyi versus President Museveni, the applications that had been brought in that petition, despite the fact that all my colleagues had declined to join me. Like I said, it's a moment, of course, that led to repercussions for me at a personal level. But looking back, I'm proud to have taken the stand that I took, that my duty to the people of Uganda was above paying, allegiance to the Chief Justice or any other authority. And my duty was to exercise judicial power in accordance with the Constitution and the laws of Uganda. And looking back, despite what has gone on in my personal life, I'm still proud that I took the decision to pay allegiance to my Constitution and to my judicial oath.
Thank you so much, Dr. Justice. I'm actually glad that you mentioned the 21 elections because that's where I'm taking this conversation. Could you take us through your experience during the 2021 presidential election, particularly explaining the constitutional reason behind your dissent? Would like to hear that.
Okay, thank you. Thank you, Council Namtevi. I think that's the word. Again, because of the time that we have, I may not go into all the details. I'll just give a summary. Again, for clarity purposes, I want to say that when Robert Kyagulanyi brought the petition to the Supreme Court in 2021, the court set itself to hear that petition, but he eventually decided to withdraw the petition. So the correct position is that the actual petition was never heard, and I think you can refer to the reasons that appellant Robert Kyagulanyi gave. I think he said, I don't believe we'll get justice at the court, so we'll take this petition to the public court. So what we decided in that case, before the withdrawal took place, there were 3 applications that were brought to the court. The first application was an application by Robert Kyagulanyi, I think is commonly known as Bobby Wine. But of course, when you come to court, you use your official name. So I'll stick to the official names, where he was asking the court to be given permission to amend his petition. And the reason he gave is that in 2021, the moment he finished casting his vote, he was put under house arrest. And it took an order of the High Court for him to be released after 10 days. And by that time, he had 5 days left to file the petition. So he argued that although he filed a presidential petition, he had lost valuable time and he needed time to amend his petition. In that case, the court considered his application, And the court did not allow him to amend. Now that I'm a retired judge, I will share this, that in the discussions that we had, I and another colleague were in favor of allowing Kyagulanyi to amend his petition. And those who listened to my discussions, to my ruling, will recall that later on I gave the reasons regarding the circumstances under which, we disallowed, but later on I said we should have allowed him to amend his petition. And at a personal level, I'll share this openly. I was in favor, but when I looked at everyone's reasoning, and I realized I was standing alone, but I also realized that despite the fact that he had had only 5 days, there was enough substance in that petition to enable the court to make the inquiry that is required to make under the Constitution. So on those grounds, I decided to go along with my colleagues, and we disallowed that application, but said, let him bring the evidence to support the allegations that he had put in. The court reasoned that the time for filing, we have a strict timeline, and we needed, we couldn't allow him to amend his petition. So I went along with my colleagues, but my conviction had been that there was enough substance in what he had submitted for us to be able to do our job. But at that position, when I delivered my reasoned rulings, I cited our earlier decision in the Mbabazi case, where we had actually allowed the petitioner, Amama Mbabazi, to amend his petition. So, as judges, we make errors. I should have stood my ground then, but again, at the time, that was the first application. Maybe I wasn't able to stand up to the pressure, at the time. And that was, counteracted by the fact that I was convinced there were grounds in the petition to enable him to proceed. So he brought a second application when he was unable to file all his affidavit evidence in court. Now, when it came to the second application, and the reasons, I think that time he had Counsel Segona, who addressed court during the hearing and said, we are having trouble collecting evidence. We are not sleeping at our homes. We can't even work from our offices. The offices of the National Unity Party are under siege. The home of the president had been, under siege. Even the president himself did not have permission to leave until, 5 days to the end of the time to file the petition. These were submissions. If one accesses the record of proceedings in the 2021 applications that were filed in that petition, these were submissions which were made by counsel for Robert Kyagulanyi. He said the polling agents, our witnesses are being locked up. They were rounded up. We can't access them. So there were all those issues. And as a result, when they came to filing their evidence, they were not able to file all the evidence in the time that the court had given them. So they made an application to be given time to file the remaining evidence in court so that the court can have all the evidence they had collected. And the court, my colleagues, the majority were 9 of us, and 8 of my colleagues said no. And in that case, I said, now is the time for me to stand my ground. So I told my colleagues on this one, I'm dissenting. And so that was an 8-1 ruling where I was very clear. And the reasoning was, if we told the petitioner that you can't amend your petition, but bring in the evidence that you have. The Constitution provides that substantive, the court, should not be, focus on procedural matters, should focus on substantive justice. And the evidence was, had already been, I think they were stopped at the courts because they didn't meet the time deadline that had been set. So for me, substantive justice demanded that we give them more time, especially given the reasons that had been given, openly submitted on by counsel for Robert Kyagulanyi in court. So I dissented. So when the court declined to give Robert time to file his additional evidence, then I think that's the time. And of course, when we went to court, there were also addresses that were being made by the Chief Justice. I think one of the famous ones was like, if you have plan B, you can go to plan B. This is, like, which I thought were not in order. If a party has come to court, you are supposed to restrict yourself to what matters before court. But anyway, based on all those, whatever considerations, I think the records are there. Kyagulanyi decided to withdraw the petition.
All right, oyo ye Justice Esther Kitimbo Kisaakye, omulamuzi eyasalawo okubanga awummula omulimu ng'entabo yava ku ndowooza ye ku musango ogwatwalibwa Kyagulanyi mu kkooti ogw'ebyokulonda. Ababadde beebuuza lwaki Bobi Wine yakeera ku makya n'ajjayo omusango, ndowooza omukyalo ono eyali omu ku abo abaali basala omusango akunnyonnyodde, era nkiwa buli omu abadde alaba ka vidiyo kaneeno otegedde. Yes, kabadde kawanvu mukko nga kali mu lulimi lunyaanyimbe luzungu, naye ndowooza mujja tutwala obudde mukawulirize. Thank you so much for watching. Nsaba Mukama Katonda abampere emusinga okwagalana naddala mu mwezi guno ogwa Ramadan. Verse strange, katukomewo.